Hello, my name is Mohamad Nuraidil bin Mohamad Razip, AP 2000095.
Hi, my name is Fahimah Binti Sairi, AP 20203.
Assalamualaikum warahmatullahi wabarakatuh. My name is Izzati Zainun Binti Zuaini.
My name is Nurul Firzana binti Azman. My entry number is AP2000196.
Assalamualaikum warahmatullahi wabarakatuh. My name is Syafikah binti Basali and my entry number is AP100-154.
Today I will present introduction Malay Reserve Land in Malaysia. Malay Reserve Land, or identified as Malay Reservation, can be said to represent land within the boundaries of that land that by law can only be owned by Malays and transferred to Malays. According to Article 86, Section 6 of the Federal Constitution, Malay Reservation refers to a land reserved for alienation to Malays or native of the state in which it is located. Malays are defined as any person who, under the laws of the state in which he resides, is treated as Malay for the purpose of land reservation. National Land Code of 1965, Section 5 of the National Land Code of 1965 define reserved land as land that is currently reserved for a public purpose in accordance with Section 62 or any provision land law. Reserved land are typically managed by officers from the state or federal government. The Malay Reservation Land Law, prior to the commencement of the Malay Reservation Enactment, was enacted on January 1st January 1914, when the Malay Reservation Enactment 1913 came into force in the Federal Malay State of Perak, Selangor, Negeri Sembilan and Pahang. In Section 62, National Land Code Act 56 1971, it states that the state authority may, by notification in the Gazette, reserve any state land for any public purpose. Any notification gazette under subsection 1 shall be describe the reserved land, describe the purpose for which the land is reserved, designate the public officer for the time being having the control of the reserved land, and be conclusive evidence that the land so described is reserved for a public purpose.
For the first case is Hanisa versus Tuan Mat in Kelantan. The first one is a Chinese woman who born in Singapore has been adopted by a Malay woman who live in Kelantan. This Malay woman who live in Kelantan has a Malay reserve land and want to transfer the land to the Chinese woman. Chinese woman has been named as Hanisa. So the transfer is null and void because according to Kelantan Malay Reserve Land Act Section 3(1), she or Hanisa must be practice a Muhammadan religion, but she still cannot get the land because she is not a native of Kelantan. She is not born in Malaysia and not a Malay woman. So the power of the ruler in council include the power to declare whether a person is a Malay or not. So the conclusion for the first case, Hanisa versus Tuan Mat, she still cannot get the land after she appeal and go to the federal court.
I will continue for the case study which Federal Court Malay Reserve Land in Kedah can be charged to a non-Malay. This case involves Oi Poh N and Enor versus Lembaga Pembangunan Langkawi 2018 1 CLJ 541. The deal was then amended to include the acquisition of home number 72, which was built on lot 3824, and lot 73, which was built on lot 3825 as the first dependent side office. The plaintiff was given vacant possession of the two apartments by the first dependent, but the plaintiff was not given title to the two dwelling. Following that, the first dependent sold lot 3824 to the second defendant and house lot 3825 to the third dependent. The plaintiff filed a lawsuit against the second and third dependent in order to reclaim lot 3824 and lot 3825. Section 6 of the Kedah Enactment number 63 Malay Reservation Enactment, because both lot 3824 and lot 3825 are Malay reserve land, any dealing in the land cannot vest in the second and third defendant who are not Malay. Section 6 of the enactment make it illegal for a Malay to sell Malay reserve land to a non-Malay. The Court of Appeal did notice, however, that the first dependent who was not a Malay under the enactment owned lot 3824 and lot 3825, which were deemed Malay reserve land. As a result, Section 6 of the enactment restriction does not apply in this circumstance. There was no evidence to substantiate the plaintiff claimed that lot 3824 and lot 3825 were owned by a Malay before the properties were declared Malay reserve land.
Okay, next is Johor Reserve Land is valid to Malay and Malaysian citizen. This case is between Zaliha Binti Sharif and pendaftar hak milik tanah Johor. Zaliha is a Malaysian citizen who is married to Singaporean citizens and got a children also in Singaporean citizens. Zaliha had a piece of land in Jalan Cermata, Kampung Kurnia, Johor Bahru. The size of the land is about 7,688 square feet. Malay in Federal Constitution Act 160 says that Malay is someone who is Malay and Muslim, can speak bahasa Malaysia and also domicile Malaysia or Singapore. But then in 1989, Johor government update and restrict the definition of Malay to Malay who is Malaysian citizens only. Zaliha's lands designed as a Rizab Melayu in 1987. Okay, the memorial was placed on the document says that land was Rizab Melayu. The plaintiff had no intention to sell the land to non-Malay, instead to pass it to her husband or her children. But Amendment 1989 prevent to Zaliha doing it so. Then Zaliha applied defendant to revoke Rizab Melayu title in his land to Johor Bahru High Court. Okay. Fortunately, her husband and her children has no position inherit the property, and endorsement terming of Rizab Melayu was made in error. At the last of the case, Zaliha success to transfer her land to her husband. This is because she applied Section 6 of Malay Reserve Enactment to erase the word of Malay Reserve. This is under Section 12 Malay Reserve Enactment 1913. So as a result, the land is no longer Malay Reserve land.
The next case is Jamaluddin bin Jaafar versus Afim bin Berhad and another appeal. So this case is about an individual. The applicant has charged his land, a Malay reserve land, to the respondent bank, Afim Bank. The respondent obtained a default judgment against the applicants and the filed bankruptcy. So, the respondent claimed that the third-party charge registered in a favour of the respondent as security for the loan granted to one T/A Leong Hin Company was null and void because the respondent is not Malay, is obtained to the Malay reservation lands enactments. So, the leave of question turn of the enactment is followed by except as otherwise provided in the enactment where any reservation land has held under a document of a title by a Malay, not right or interest, then shall vest in any person who is not a Malay, whether by transfer sales in execution of a decree sale of the intents of a charge. So, while Section 6 of the enactment prohibits a charge from selling Malay reservation land owned by a Malay to a non-Malay, it does not prohibit the creation of a charge over Malay reservation lands or owned by a Malay in favour of a non-Malay.
And the case issue is Datuk Haji Mohamad bin Daud versus Bank Islam Malaysia Berhad. The plaintiff of the case is Datuk Haji Mohamad bin Daud, and the defendant of this case is Bank Islam Malaysia Berhad. The date of the case on 6 May 1984, the plaintiff entered into the property sale and purchase agreement with an Islamic bank based on a BPE20603 agreement. Islamic bank bought the property for RM 520,000 cash, then we sold it to the plaintiff for RM 629,000 debt. The charge is made on the property is favor of the defendant security. On 5 October 1994, the plaintiff made an application that all the transactions of the charge were invalid as execution of the agreement did not comply with agreement regulation section 7 and 12 of Kelantan Malay Reserves Enactment 1930. The legal issue of the case is implementation of the agreement violated the provision of section 7 and 12 of the Kelantan Malay Reserve Land Enactment 1930 and therefore is invalid. It has been obtained is an incomplete or invalid manner as provided by section 340 of the National Land Code 1965. The court of decision is dismissed the appeal with cause because the implementation of real estate sale and purchase agreements is part of Islamic banking procedure. Therefore, the agreement to purchase the property does not violate the provision of section 7 and 12. The plaintiff may use the section 340 if there is a defect in the execution of the charge document. Once study has been done, the mortgage does not show a defect. The charge document is registered in accordance with procedure contained in the code with legislation does not conflict with the enactment. So the conclusion of the case, the purchase agreement did not violate the provision of section 7 and 12 of the Kelantan Malay Reserve Land Enactment 1930 as there was no attempt to manage the land contrary to the provision. Thus, there is no reason to disagree with the opinion of the trial judge.
Okay, so for the conclusion, there is two uniform of law. First, Federated Malay State Reservation Enactment, and the second was state government, known as Unfederated Malay State for Perlis, Johor, Kelantan, Terengganu and also Kedah. Okay, at the end of the first case was unsuccessful because Hanisah not Malay and native of Kelantan. Okay, for the second case, also unsuccess because Oi Poh Eng was born in Singapore and not Malay. For the third case, successful because did not violate Kelantan Malay Reserve Land Enactment. Fourth case, also successful because Zaliha revoked the title of Rizab Melayu, and the last case unsuccessful because he was not a Malay. That's all. Thank you.